Good afternoon. Welcome to the first of our two-part webinar series, which provides an overview of the significant construction and adjudication cases of 2017. This first webinar will focus on our chosen top 5 construction cases. So in today's webinar, we'll be highlighting the main facts and legal points from the top 5 construction cases of 2017, and we'll identify specific lessons to be aware of for construction contracts and claims. The second webinar in this series is on Tuesday the 20th of February, and that will focus on our chosen top 5 adjudication cases of 2017. All of our webinars are recorded and are available on our Vimeo site, so if you're not able to join us live or would like to listen again or share with colleagues. So I'm Kate Gillis. I'm an associate in the Construction and Special Projects team, specialising in construction and engineering dispute resolution, and I'm based in Sheffield & Wedderburn's Edinburgh office. I'm joined today by Miranda Cannibal, a solicitor in my team. The team regularly advises on construction contract issues and disputes across a range of projects and clients, and we have a great deal of experience in court, in arbitration and adjudication, where our arguments have to reflect ever-evolving judicial approaches to construction law and contracts. So this experience really forms the basis of our strategic advice and also what we'll share with you today. I'll hand over to Miranda, who will take us through the agenda for this webinar.
Thanks, Kate. Firstly, we will look at the case of Interserve Construction against Hitachi, where the Technology and Construction Court, or TCC, decided that an employer had to issue a default notice before terminating the contract, despite termination being at the sole discretion of the employer. We will then discuss Highguard against Eon Climate and Renewables, where the Supreme Court overturned the decision of the Court of Appeal and imposed a more onerous fitness for purpose obligation on the designer. Next will be North Midland Building against Holmes Limited, where the TCC upheld a contract clause expressly disallowing a building contractor's claim for an extension of time in cases of concurrent delay. We will then consider Trent Engineering Limited against Mott MacDonald Limited, which concerned a consultant who attempted to revoke access to BIM during a dispute over unpaid invoices. And finally, we will look at Riva Properties Limited and others against Foster & Partners Limited, where damages were sought against an architect for negligently advising on the cost of a project.
Whilst these are all English cases, much of our contract law is common across the border, as there are a number of standard form contracts used for the construction projects. So English courts tend to have a larger number of disputes and appeals than Scotland, and therefore key lessons can be learned from looking down south, and that's why we're focusing on these cases today. I should add that whilst other important cases were obviously decided in 2017, we can't deal with all of those in the time available.
We begin with Interserve against Hitachi. In May 2014, Hitachi, the main contractor, engaged Interserve as a subcontractor under a design and build contract for various civil works and building facilities at an energy from waste plant in Worcestershire. Work proceeded from 27th of May 2014 until by letter dated 6 July 2015, Hitachi sought to terminate Interserve's employment following Hitachi becoming dissatisfied with Interserve's performance and alleged delay in proceeding with the works. Now, Clause 43.1 of the contract stated that if Interserve committed a prohibited act as defined in the contract, then, subject to subclause 43.1a, and without prejudice to any other rights or remedies which the purchaser may possess, the purchaser may forthwith, by notice, terminate the employment of the contractor under the contract. Clause 43.1a then went on to say that in the case of a default by the contractor under various termination events, the purchaser may, at its absolute discretion, notify the contractor of the default, and if the contractor fails to commence and diligently pursue the rectification of the default within a period of 7 days after receipt of notification, the purchaser may, by notice, terminate the employment of the contractor. Hitachi did not issue a default notice prior to producing its letter terminating the contract, and shortly thereafter steps were taken to remove Interserve from the site. Interserve raised proceedings against Hitachi seeking a declaration that the default notice and 7-day rectification period was a condition precedent to the termination under the contract. Interserve argued that the reference to absolute discretion was the Hitachi's decision to terminate and not to whether they issued a default notice or not. Hitachi argued, on the other hand, that the giving of a default notice was discretionary, conform to clause 42.1a, and their choice not to produce a default notice was valid. Now, given the wording absolute discretion in clause 42.1a, you may have expected the court to have sided with Hitachi. However, the judge agreed with Interserve and held that a default notice required to be served and a 7-day rectification period allowed before termination was triggered. The judge held that the natural meaning of the words subject to meant that the right to terminate was conditional on the operation of clause 43.1a. The judge went on to say that Hitachi's interpretation of the clause made the phrase subject to meaningless and commented that it would not be the intention of the draftsman to have a redundant phrase in a carefully drafted bespoke contract. Whilst the counter-argument by Hitachi was that this rendered the phrase absolute discretion redundant, the judge found this not to be the case and held the phrase absolute discretion emphasized Hitachi's right to give notice and thereby commence the termination process. This case serves as a valuable lesson that the courts will not look at contractual clauses in isolation and will often look at the contract as a whole in order to determine the proper meaning of the words. In cases involving bespoke contracts, the courts will resist interpreting the contract in a way which will make part of a clause redundant if it can be avoided. It should therefore be borne in mind that if there are clauses within a contract which are ambiguous or contain superfluous wording, that clause may be interpreted by a court in a way that you did not consider at the time of negotiating the contract. Legal advice should be sought wherever possible on the operation of such clauses to try and prevent these types of disputes from arising. Further, construction contracts of this kind often make a provision for a rectification period of some sort following a default, so that the contractor, or subcontractor in this case, is given time to correct defects prior to termination. Therefore, if you come across a similar clause where a default notice is mentioned but is at the discretion of the employer or main contractor, our advice would always be to err on the side of caution and issue a default notice so that a contractor or subcontractor cannot rely on this to levy damages for wrongful termination.
Thanks very much, Miranda. The next case that we're going to look at is MT Highguard against E.ON Climate and Renewables. Now, this one concerned a lengthy litigation. It regarded who was responsible for remedial works, which cost in excess of €26 million. So in this case, Highguard, the contractor, agreed to carry out the design, fabrication and installation of the foundations for 60 wind turbine generators, and that was for the Robin Rig offshore wind farm in Solway Firth in Scotland. And this was for E.ON as the employer. The contract contained various requirements which the foundations had to meet. These included that the foundations had to be in accordance with E.ON's technical requirements, and those, in turn, required the foundations as a minimum to be in accordance with an international design standard document known as J101. That was produced by an independent Norwegian classification agency, so it was a standard technical document for foundations. Foundations also had to have a lifetime of 20 years. They had to be designed with due care and diligence and in accordance with good industry practice, and they also had to be fit for purpose. So Highguard completed their design in accordance with the standard guidance J101 as per the contract. However, that standard, J101, contained a mathematical error, and that resulted in the strength of the foundations being overestimated. And after 3 years, the foundations began to fail. So the parties agreed that remedial works were to be carried out to correct this mathematical error. However, they did not agree on who should bear the cost of doing this work. E.ON argued that Highguard should bear these costs, since the foundations patently didn't have a service life of 20 years, whereas Highguard contended that E.ON should pay, since Highguard had in fact designed the foundations in accordance with the International Design Standard 101 and arguably complied with their contractual obligations. At first instance, the TCC decided that Highguard was liable. This is because the contractual obligations were additional to each other rather than being inconsistent. So because Highguard had failed to meet the requirements that the foundations would have a lifetime of 20 years, then they were in breach. The Court of Appeal, on the other hand, held that as the contract terms had precedence over the technical requirements, the terms of the technical requirements were not enough to establish that Highguard had to give a warranty, effectively, that the foundations would function for 20 years. When it came to the Supreme Court, the judges there reversed this decision, found the TCC was in fact correct, finding Highguard liable for the remedial costs. The main issue considered by the Supreme Court was whether Highguard was in breach of contract, despite the fact that it had used due care and professional skill, it had adhered to good industry practice, and it had complied with J101. The Supreme Court found that Highguard had breached its requirements under the contract, and that was for the following reasons. Firstly, the court noted that the contractor was expected to take the risk if he agreed to work to a design which would render the item incapable of meeting the criteria, and that's even if the customer has specified or approved the design. Secondly, paragraph 3.1 of the technical requirements provided that those requirements were minimum requirements. Paragraph 3.2 went on to say that Highguard had responsibility to ensure the works were designed to more rigorous requirements or parameters. Therefore, as the technical requirements were minimum standards, it was Highguard's responsibility to identify the need to improve on the design where that was appropriate. And finally, the court found that the contract clearly imposed a duty on Highguard to design foundations that had a lifetime of 20 years. The court found there was no reason to say that this was an improbable or unbusinesslike interpretation, as it was simply taking the words at their natural meaning. The court was not persuaded that because this requirement was in a technical document rather than the main body of the contract, it was somehow lesser than the other obligations. Now, this might seem a harsh decision by the Supreme Court, particularly because Highguard complied with the J101 standard. However, it is common for contracts to incorporate such technical documents, and in this case, the technical requirements formed part of the contract, and within those was the 20-year design life. The Supreme Court found no reason not to hold Highguard to these, and that's consistent with the general view of the court that they will not deprive the parties of their bargain. So this case acts as an important reminder that due care and attention should be paid to all of the stated performance requirements and standards stated in the various contractual documents, not just those, for example, stated in the principal technical specification. It also highlights the importance of ensuring that the contract reflects exactly what is intended by the parties, so that there's limited scope for dispute over the interpretation of the contract.
Great, thanks very much, Kate. We'll now move on to North Midland Building against Holmes Limited. Just picking up on one of the questions that's been put to us with respect to Interserve. No, this decision we are not aware of an appeal. This was held in the Technology and Construction Courts, which is different actually to the case we are just about to discuss, which does have an appeal outstanding to the Court of Appeal, which we're expecting to receive a judgment on soon. So moving on to North Midland Building against Holmes. In this case, Sidon, the employer, engaged North Midland, the contractor, to design and build a large private residential property. The contract was a JCT design and build contract with various amendments, including one to the extension of time provisions. The amendment discussed by the court expressly provided that any delay caused to the contractor by a relevant event, meaning an event which entitles the contractor to claim an extension of time, which is concurrent with a separate delay for which the contractor is responsible, shall not be taken into account for the purposes of calculating an extension of time. The work on the property was delayed, and North Midland claimed an extension of time. Sidon allowed this partially, but used the amended provision just discussed to reject other elements of the ERT claim. Sidon argued that some of the events which caused the delay were concurrent with events for which North Midland were responsible. Thereafter, North Midland commenced proceedings and asked the court to make a declaration that this offended the prevention principle. To elaborate briefly, the prevention principle is the principle that no party can require the other to comply with a contractual obligation if they themselves have prevented or impeded the other party from doing so. For example, if an employer prevents a contractor from carrying out works on time, for instance by not allowing them on site, the employer cannot then force the contractor to comply with the time provisions in the contract. Now, usually concurrent delay is where a period of delay can be attributed to both the employer and the contractor. If no specific provision is made for concurrent delay, the contractor would normally be granted an extension of time, but would not be able to recover any associated loss or expense. However, in this case, provision had been made to allocate all the risk of concurrent delay to the contractor. North Midland argued that the prevention principle applied here, as Sidon would be trying to enforce a contractual obligation which they themselves had prevented from being achieved. This would result in time being at large, meaning that North Midland would only have to complete the works within a reasonable time, and that Sidon could not levy liquidated damages for the delay. Sidon, on the other hand, argued that the extension of time clause, which allocated the concurrent delay risk to the contractor, should be upheld. The court upheld the clause and refused to grant the declarations sought by North Midland. The judge found that the clause relating to the concurrent delay was crystal clear, that risk had been clearly allocated by agreement, and the prevention principle did not arise. The court stressed that parties are free to agree whatever terms they wish to agree, with the obvious exceptions such as illegality. But there was no rule of law that prevents parties from agreeing that concurrent delay be dealt with in a particular way. This is a relatively complex area of law, which is why parties are often reluctant to include clauses relating to concurrent delay in their contracts, in order to avoid using wording which could be rejected by the courts. However, this case confirms that clauses like this will be upheld as long as they are unambiguous. If parties wish to expressly provide for who takes the risk of concurrent delay, they should therefore ensure that there is no doubt where the risk has been allocated in the clauses they draft. This is yet another case where the courts have held the parties to the wording of the contract that they have agreed, and again demonstrates that clarity is key in drafting. The judgment may also increase the use of this type of clause in construction contracts. However, as mentioned at the start, an appeal is outstanding in this case, so we may receive further comment on this point.
Okay. Next up, we have the case of Trant Engineering Limited against Mott MacDonald. This case regarded the Mid-Atlantic Power Project, which is a £55 million project to construct a power station on a UK military base in the Falkland Islands. Trant were employed by the Ministry of Defence for the project and engaged Mott MacDonald for the initial design consultancy services, which included the preparation and implementation of the Building Information Modelling, BIM. During the project, disputes arose over payment and other contractual terms, which included a dispute as to whether there was a contract between them at all, since the contract had never been signed by Trant. As a result, Mott MacDonald argued that Trant's entitlement to use BIM was at large. As BIM coordinator, they revoked Trant's access to BIM, along with other parties involved in the project. Now, Trant applied to the court for an interim injunction requiring Mott MacDonald to restore access to BIM while the dispute was being resolved. Trant argued that even if they were successful in the dispute, the damages they would receive would not be sufficient to match the losses that they would incur if they couldn't access BIM in the meantime and they had to start the whole design again from scratch. This was because under the contract, Mott MacDonald had a total liability cap of £1 million. The court did grant that interim injunction. It was held that even if it was determined that there was no contract, there was a high degree of assurance that Trant was entitled to access the design data, particularly since Trant had previously had access to BIM before it was suspended by Mott MacDonald. The court ordered Mott to restore access to BIM, and subject to Trant making a payment into court, that was £475,000, pending resolution of an overarching dispute. The money that Trant had to pay in was for payment of an invoice because they had not issued a pay less notice against it. So this case sparked interest. It's the first reported case that we've seen involving the use of BIM. BIM is being used increasingly more in the design of complex construction projects in line with the advancement of technology. And so disputes over the use of BIM may be an issue that the industry begins to face more and more as its use becomes more commonplace. In terms of what we can take from this case, it raises the question of which party is most appropriate to host the information held on BIM. Consideration should be given to which party is at the centre of the information flow, as well as whether they have the technology and capability to host this information. BIM can often be integral to the running of a project with a large number of parties contributing to the information held on it, and so revoking access could be disastrous to those relying on the BIM information. As mentioned in our last webinar series on the new NEC4 contracts, a clause on BIM has actually been added in the new NEC4 contract, covering issues such as liability and information requirements. We would therefore encourage the inclusion of clauses like this in contracts for projects using BIM so that there can be no doubt as to the operation of BIM and access rights of respective parties. It is perhaps comforting that the court did not allow the consultant to hold the employer to ransom by revoking access, but for the avoidance of doubt, provision should be made which covers access in the event of a dispute in any BIM clause.
The last case we will look at today is Riva Properties Limited against Foster and Partners. This was a professional negligence claim brought against a firm of architects for wrongfully advising that the cost of a project could be value engineered down to a lower figure. The claim was brought by 4 companies who were all controlled by one person, Mr. Dahona. Mr. Dahona engaged Foster's to design a hotel near London Heathrow, through one of his companies in 2007, particularly Riva. Mr. Dahona's position was that his budget for the project was $17 million. Foster then produced a scheme costed at $195 million. On the basis of that, Mr. Dahona increased his budget to $100 million. That on the basis that although Foster's had costed at $195 million, they advised him that it could be value engineered down to $100 million. However, it was not possible to value engineer down the scheme, and Riva could not secure the funding to build the hotel. By this point, Riva and Mr. Dahona had incurred over $4 million in professional fees alone. On that basis, Dahona, through Riva, raised an action and claimed for fees on the basis of damages for professional negligence, along with over $16 million for loss of profits as a result of the hotel not being built. The court held that Foster did breach their duty under the contract for incorrectly advising that the design could be value engineered down to $100 million. They awarded over $7.5 million to Riva for damages for breach of contract. However, the court did reject a claim for loss of profits. The judge said that Riva's inability to secure funding was partly attributable to the global financial crisis in 2007 and also to a lack of cash reserves in the company. Now, this case might strike fear into architects and other professional bodies, as one would not normally expect an architect to be held liable for financial advice. However, in this case, the contract expressly provided that as part of their appointment, Fosters were to identify their client's requirements and possible constraints on development, and to prepare a strategic brief confirming key requirements and restraints. The judge here had no difficulty in holding that a client's budget for a project is a constraint. Therefore, a key lesson to be taken from this case is that consultants should thoroughly review the scope of their duties in the appointment documents and ensure that they are not agreeing to any tasks which are outside their capabilities or what they cannot deliver on. This is another example of the courts holding parties to the bargain that they have agreed. This case should also encourage consultants to think about the way they behave towards their clients. The judge in this case was scathing of the way Fosters carried out the design, with no consideration of the budget, calling them disingenuous and obstructive, and describing their behaviour as rather grubby. Apart from the obvious point that acting unprofessionally is likely to deter future business, this case shows that it may also have an influence on how the court approaches the disputes and may well tip the balance in favour of the party who has acted honestly and in good faith.
Thank you very much. So, what can we take away from today? Firstly, this webinar highlights the importance of keeping up to date with case law. The law is constantly changing, and it's especially important in the construction industry to stay alive to these changes. This puts you at an advantage, either by being able to make new arguments or take advantage of new case guidance, or by being able to react appropriately when such arguments are made to you. Further, a common theme of the cases discussed today is that the courts will hold parties to the contract that they agreed, and are reluctant to overturn contractually agreed terms. This emphasises the importance of good drafting. Construction contracts are notoriously large and complex, so keeping on top of your requirements under the whole contract and ensuring the drafting is clear is essential to avoid potential disputes. It's difficult to argue against clear terms written on the page when they've been signed and agreed by both parties, even if you believed you meant something else. We've now come to the end of the webinar. We hope it's been useful and interesting. We still have a few minutes left, so if there are any questions, then please type those into the chat box just now. While you're doing so, I'll take the opportunity to remind you that the second webinar in this series will take place on Tuesday the 20th of February at 1 o'clock. This will be a roundup of our chosen top 5 adjudication cases of 2017, and we'll again consider the factual background, legal points and lessons to be learned from each case. If you haven't signed up for this already, please do so by visiting the News and Events section of our website. And don't forget you can listen to these webinars or share them with colleagues again. Also, our next seminars are in-person breakfast seminars we're hosting in Edinburgh on the 6th of March and Glasgow on the 8th of March. We'll be looking at current issues affecting the construction industry, and particularly those arising out of the Carillion situation. And it would be good to see some of you there. Further details of that will be sent out by email and will also be available on our website. Our breakfast seminars are not only valuable from a knowledge update perspective, but they do also offer networking opportunities and a chance to discuss issues in more detail with us and with other attendees. Okay. Well, we don't actually have any questions today. If there's anything that anyone would like to ask, feel free to contact either myself or Miranda after the webinar. But otherwise, thank you very much for your attendance and for listening. Thank you.